So guys, this next news story, a man who shot dead a custody sergeant while handcuffed in a police cell will die in jail after being given a whole life order today. Louis de Zoysa was convicted of murder last month after jurors were shown distressing CCTV footage of the 26-year-old using a legally bought revolver to gun down Sgt Matiu Ratana. Sgt Ratana died in hospital despite the efforts of medical staff after being struck by 2 bullets in a holding cell in Croydon in South London in 2020. The jury, which convicted de Zoysa, a former tax office data analyst, and he was not told, a shortened infantry rifle, numerous types of ammunition, a pipe gun, and a dummy launcher were found at his rented property after the killing. Sentencing him today, Mr. Justice Johnson said Sergeant Ratana had devoted his life to public service. He put himself in danger to protect the public and protect and safeguard those who came into custody. His family are all rightly immensely proud of the man you killed. They recognise that you bear the sole responsibility of his murder. They say in a victim impact statement that for the officers on duty that night, they have nothing but support, admiration and respect. You said that you had an autistic meltdown. You said you had diminished responsibility. The judge went on to say you did not have an autistic meltdown. Your actions were voluntary, controlled and deliberate. You acted in cold blood. You intended to kill Sergeant Ratana. You deliberately aimed the gun at his chest at near point-blank range. Even as he fell to the ground, you re-aimed and fired a second shot at him. Autism does not cause people to be violent. Autistic people are no more likely to commit violent offences than anyone else. Autism is not to blame for your decision to murder Sergeant Ratana. You are responsible for that. He said de Zoysa had begun planning to murder a police officer following his arrest, starting by lying to police and misdirecting them by admitting to carrying cannabis.
You can just keep your hands out your pockets for now. I'll take it and have a look in a minute. All right. The reason is there's a lot of burglaries in this area. Okay. Yeah. It's 1:30 in the morning. I don't know who you are. You probably got a totally legitimate excuse. All right. But at the moment you're walking down the road with a duffel bag. All right. Which I believe may have stuff going to equipped to do a burglary. All right. So I'm just going to search you.
In this pocket, I've got my ID.
Perfect. Okay, that's fine. Don't put your hands in your pockets. Hey, hello. Don't put your hands in your pockets. Okay. You okay? You're just going to be searched, mate. You're not under arrest. I just need to search you. You okay? All right. Just a bit nervous, yeah?
My parents, please.
Okay. Are they expecting you home? Okay, that's fine. All right. That's fine.
You give me 2 seconds. You give me 2 seconds. Do you want me to hold that? It's alright. You're not in trouble. You're not in trouble. So my colleagues just explained. He was just going to search you, see if you've got anything, and then you're going to be gone. This is all being recorded on body worn camera, okay? You're not in trouble. My colleagues just said to view the grounds, and he was just going to quickly search you, and you're free to go.
Okay.
You're entitled to a copy of the slip. Okay?
I'm going to confess, okay, in that bag is non-medical cannabis.
Okay. How much have you got in there?
I've got maybe 3 or so grams.
Okay. All right. I'm still going to have to search you. All right.
Yeah.
So just pass me your phone and your mask. Okay. All my concern is at the moment is if you've got anything on that's going to hurt me or you. Any needles, any razor blades, anything like that. Okay, fine. Because you just told me you've got drugs on you, I'm just going to have to put you in handcuffs while I search you. The reason... What's the matter? So the reason for that is people try and do silly things when we search them. They try and hurt themselves, they try and hurt police officers.
Hey,
all right?
Can you take me into the car, please?
Why? Don't resist. Listen to me very carefully.
I know.
Don't resist.
Okay, we'll put you in the car, but put the handcuffs in first, yeah?
Okay.
Is it someone's watching us? Or...
Look, take the bag, please. Thank you.
Why do you want us to sit you in the car?
Just worried, please.
Why? Why are you worried?
Just...
You think your parents might see?
No.
He said you knew the gun worked. You knew each cartridge was likely to kill if fired directly at a person's chest. You had no lawful or good reason for possession of a gun. You deliberately concealed the gun from police. You told them they had cannabis to conceal their attention from the gun. When police found cartridges, you lied and said they were not real. You made strenuous and successful effort to retrieve the gun whilst it was concealed behind your back. You had time and space to consider what to do. You posed a lethal risk to Sgt Ratana and the two officers in the holding room. Zoysa said his hypermobility allowed him to blast the 54-year-old even though his hands were cuffed behind his back. So Sgt Ratana was a New Zealand-born officer, and he was just 2 months away from retiring when he was killed in the early hours of September the 25th, 2020. I just want to say rest in peace, Mr. Ratana, and my condolences go out to your family. He was the first police officer ever killed inside a police station in the UK. Zoysa was arrested on the street, and police officers found 7 bullets on him and 2 bags of cannabis. But the search failed to detect the gun, which Zoysa was still hiding in a holster under his armpit when he went to the Windmill custody centre in Croydon. Zoysa claimed he was having an autistic meltdown and did not deliberately shoot Sgt Ratana, and denied murder but was convicted by a jury at Northampton Crown Court. He had bought the revolver at an online antiques auction in June 2020 and made the bullets himself on the farm where he lived. 9 firearms offences relating to the gun and other weapons found at his home were left to lie on file today. 1 bullet hit Sgt Ratana in the chest, while the 4th shot hit Zoysa in the neck, and he suffered a stroke which left him with severe brain damage. They had been worried Zoysa would go bananas in custody before he killed the officer who had served in the Met since 1991. Sgt Ratana's partner, whom he had been planning to propose to before he died, said, "Losing Matt, my partner of 5 years, was the most devastating event that's happened in my life. If he was alive today, we would be celebrating 8 years together. When I was told Matt had been shot, my whole body just froze. I felt shock and cold. The words seemed to come out in slow motion. I can remember falling to the floor, screaming and crying uncontrollably. Every day I'm still waiting for him to walk through the door. I remember seeing the man who shot in November 2022 and found it extremely difficult to face him, and remember thinking how unfair it was. I was overwhelmed with grief and pain seeing him and his family and knowing they still had their son. The man who shot Matt gets to remain on this earth and he doesn't. He was an amazing man and didn't deserve to die." Prior to the trial, I was given the opportunity to watch the CCTV and have some kind of understanding of what happened. It was so difficult to hear Matt's voice and see him in the video being a custody sergeant, a role he loved, knowing that when he went into that room, his life would be over a few seconds later. I would never wish anyone to go through what has been an unbearable few years with the uncertainty and delay of the court procedure, waiting for someone to be held accountable for murdering Matt. I cannot forgive the person who shot Matt and tore my life apart. My heart is broken and my heart feels empty. Words cannot explain the trauma of losing my courageous, gentle giant in such a way. So Zoysa's mother, who is a Dutch to English translator and a local Green Party activist, also attended court today. In a letter to the judge, she pleaded for her son to be given a chance to rehabilitate and then come home to her and his siblings. So Zoysa had claimed the gun had gone off by accident, but laboratory tests showed this was not possible. Analysis of his devices revealed an interest in weaponry and violence, including right-wing extremism, Islamic extremism and homophobia. His defence barrister Imran Khan, KC, said Zoysa had experienced violence as a child both at home, from his father and at school. He said Louis Zoysa's future will never be the same again. It was permanently reshaped as a result of the events that day. He said Zoysa was subjected to violence as a child both at school and by his father. He said Louis had a fascination with guns in the formative years of his life and he had the potential for a good future ahead of him as a young man, but these events resulted in him being convicted of murder and damage to his brain. That damage means that the precise motive for why he shot Sgt Ratana will never be known, and we may never know the reason why he had a revolver on him. Louis is not an evil man, he's not a wicked man, he's not a monster. The court is not sentencing a neurotypical offender. He said that prison can be a dangerous environment for those with autism. So guys, this is a new story coming in, and here's the sentencing that happened today.
He was the custody sergeant at Croydon police station. He had devoted his life to public service. He put himself in the way of danger to protect the public and to protect and safeguard those who came into custody. You have robbed Sue Bushby of their future life together, Diane Peachy of her stepson, Luke Ratana of his father, and Jessica Williams and James Young of their brother. They are all rightly immensely proud of the man you killed. They recognise that you bear the sole responsibility for his murder. They say in their victim impact statements that for the officers who were on duty that night, they have nothing but support, sympathy, admiration and respect. Luke Ratana himself is a police officer. He knows as well as anyone the dangers they face day in, day out, and the difficult circumstances in which they operate. You said that you had an autistic meltdown. You said that you had diminished responsibility. The jury disagreed. The jury found you guilty of murder. The sentence for murder is set by law. It is life imprisonment. So I sentence you to life imprisonment. I make a statutory surcharge order in the required sum, and I have already made a deprivation order in respect of some specified items that were seized from you. I am satisfied that you will be held in conditions that will ensure that your medical needs can be accommodated and that you can be treated in accordance with your rights. The operational manager for the Category A team at His Majesty's Prison Belmarsh has confirmed that they have the resources and facilities to provide the care that is required. The Secretary of State can, if necessary, make an order for your detention in hospital. I refused an application to adjourn sentence. I am satisfied that there has been ample time to obtain any information that is relevant to sentencing. I have a great deal of medical evidence about your condition, and I have been given very great assistance from your lawyers. I have all the information that is necessary to pass sentence. The law requires the court to decide whether to set a minimum term order or a whole life order. A minimum term order means that you can be considered for release after the minimum term. A whole life order means that you remain in custody for the rest of your life. A minimum term order must be set unless the court is required to make a whole life order. The court is required to make a whole life order if the seriousness of the offence means that a minimum term order should not be made. A sentence of imprisonment for life with a whole life order is a sentence of last resort. It is for cases of the most extreme gravity. It is reserved for cases where that is what is required to secure just punishment. In the event of any doubt as to whether that standard is reached, a minimum term order is likely to be appropriate. If the seriousness of the offence is exceptionally high, then the starting point is a whole life order. The law identifies cases that are normally of exceptionally high seriousness. They include the murder of a police officer or a prison officer in the execution of his or her duty. In those cases, the starting point must normally be a whole life order. You murdered a police officer in the execution of his duty. So this case is within a category where Parliament has said the starting point is normally a whole life order. Depending on the facts of the case, the starting point can be changed from a whole life order to a minimum term order. but that can only be done if it is justified, and it will only be justified if the seriousness of the offence is not exceptionally high. After deciding the starting point, the court must consider any aggravating or mitigating factors. If the starting point is a whole life order, then depending on those factors, the court could impose either a whole life order or a minimum term order. So the final sentence depends on the starting point and then the balance of those other factors. I turn to the events of the 25th of September 2020. The events are captured on CCTV and body-worn video evidence. I am sure of the following. 1. When you were stopped, you were in possession of a gun. The gun was a revolver which had 6 chambers. Each chamber contained a bulleted cartridge. You were also in possession of a pouch containing 7 additional bulleted cartridges. Each of those cartridges was suitable for firing from the gun. 2. You knew you were in possession of the gun and cartridges when you were stopped by the police. You knew the gun worked. You knew the cartridges worked with the gun. You knew that each cartridge was likely to kill if fired directly at a person's chest. 3. You had no lawful or good reason for the possession of the loaded gun or the cartridges. 4. You deliberately concealed the gun from the police. You told them you had cannabis to focus their attention on that. You did that in the hope that it would make it less likely that they would find the gun. When the police found the 7 cartridges, you lied and said that they were not real. 5. You made strenuous and successful efforts to retrieve the gun whilst you were handcuffed behind your back. There was no lawful or good reason for you to do that. 6. You had time and space to consider what to do. It was 50 minutes between the time you were stopped and the time you shot Sgt Ratana. There were 8 minutes after arrival at the police station before you were brought out of the van. You had already retrieved the gun at that point. During those 8 minutes, you were left entirely alone without any distraction. You were able to think about what you would do. 7. You posed a lethal risk, not just to Sgt Ratana, but also to the 2 other officers who were in the holding room, and also to any other officers and anyone else in the area. 8. You had twice been arrested before without incident. On this occasion, the video evidence shows that you were treated with conspicuous compassion and kindness, or, as Luke Ratana put it in his victim impact statement, with respect, dignity and understanding. None of the officers gave any reason for you to feel at risk of harm or threat. 9. You did not have an autistic meltdown. Your actions were voluntary. They were controlled. They were deliberate. You acted in cold blood. 10. You intended to kill Sgt Ratana. You deliberately aimed the gun at his chest at near point-blank range. The first shot caused fatal injuries. It caused Sgt Ratana immediately to fall to the ground. Even as he fell, you re-aimed and you fired a second shot at him. Parliament has said that the murder of a police officer in the execution of his or her duty is normally an offence where the seriousness is exceptionally high. Parliament has recognised that there may be cases where that is not so. I have considered the impact of your autism on your culpability. In doing so, I have paid close attention to the Sentencing Council's guideline. You were not having an autistic meltdown. You were in control of your actions. Expert evidence during the trial indicated that autism does not cause people to be violent. Autistic people are no more likely to commit violent offences than anyone else. Autism did have an impact on your social communication and your social interaction, but you were able to make yourself understood. That included when you requested an appropriate adult and a solicitor. Any communication difficulty or any difficulty with social interaction had no bearing on your decision to kill Sgt Ratana. Autism can also result in restricted and repetitive patterns of behaviour, activities or interests. It may be that this helps explain your interest in firearms, but it does not help explain your decision to kill Sgt Ratana. Autism also affects how you perceive things. For example, you are not tolerant of noise. But again, that does not explain your decision to kill Sgt Ratana. I am satisfied that you were able to exercise appropriate judgment. You were able to make rational choices. You were able to understand the nature and consequence of your actions. There was no sufficient connection between your autism and the murder to reduce your culpability by reason of your autism. Autism is not to blame for your decision to murder Sgt Ratana. You are to blame for that. There is no reason to depart from the normal rule that the seriousness of this type of offence is to be regarded as exceptionally high. I therefore adopt the starting point of a whole life order, but that is then subject to the other factors and the aggravating and mitigating balance. I turn first to the aggravating factors. Sgt Ratana was performing a public service and exercising a public duty. That factor is inherent in the starting point of a whole life order. It is not therefore a separate aggravating factor. Planning and premeditation. Your decision to kill Sgt Ratana was not immediate or panicked. There was a degree of both planning and premeditation. Prior to being stopped by the police, I accept that you had no plan to murder a police officer. But once you had been stopped and detained, and the period thereafter, you did form a plan to do so. That plan took shape in a number of ways. You lied to the officers. You said you did not have anything that could hurt them. You told them that the cartridges that they found were not real. You pointed them in the direction of the cannabis in your bag, diverting their attention from your body where the gun was concealed. You went to considerable and probably painful lengths to retrieve the gun in a way that was undetected. Once you had hold of the gun, you kept it hidden under your coat. As you moved from the van to the holding cell, you sought to keep your back close to the wall to help conceal the gun. All of those things show a degree of planning and premeditation, albeit I accept that was all within the context of the period between the stop and your arrival in the holding cell. It is nonetheless a significant aggravating feature. Use of a firearm. You acquired the gun and then you manufactured the bulleted cartridges for it. You loaded each of the chambers of the gun and you took it with you with other cartridges as you took a journey in public. You took it into the police station. those actions created a significant risk to members of the public and to all those in the police station, including other police officers who are also exercising public duties. After the lethal shot, you fired 3 further shots. They, and particularly the 3rd and 4th shot, posed a high risk to the lives of 2 other police officers. Your use of a firearm is a further significant aggravating feature. The use of a gun to commit the murder means in itself that the seriousness of the offence is particularly high. I turn to mitigating factors. First, your upbringing. You had a difficult upbringing. You were bullied at school. Your father beat you. That is sad and distressing. But you did well at school. You got 3 A's at A-level, you had a job at HMRC, and you did well at that job and were valued in it. You had a girlfriend, and I have read many statements from those who knew you, including your former girlfriend, and including colleagues at work. The difficulties you had to endure in your childhood is a mitigating factor, but it does not significantly reduce the seriousness of this offence. Age. You were 23 at the time of the offence. You are now 26. You were highly intelligent. You had studied independently. You were in work, and you were living independently. There is no evidence of any lack of maturity. A whole life order can only be imposed on an offender who is over the age of 21. You were over that age, but not substantially so, and you are still within the age bracket where neurological development can impact on maturity. But you are close to the top end of that age bracket. Your age is a mitigating factor. Good character. You had no previous convictions or cautions for any offence. That is a mitigating factor in your favour, and I take it into account. But its weight is limited because I am sure that you had been engaged in unlawful conduct in relation to drugs and firearms. Autism. I have already explained that your autism does not significantly reduce your culpability. It is a mitigating factor to the extent that it affects the impact of imprisonment on you. I have considered detailed academic research on the experience of autistic prisoners. That impact is complex. In some respects, it is possible that you may have less difficulty enduring loss of liberty and a structured regime than others. But in many other respects, it is likely that you will find imprisonment more difficult, particularly in how you deal with staff and other prisoners, and the effect of noise and other sensory stimuli on you. On balance, I accept that you are likely to find prison more difficult than a neurotypical prisoner. I take that into account. Your injuries. After shooting Sgt Matiu Ratana twice, you fired 2 more shots. One hit the wall of the cell, mercifully missing the 2 officers who were bravely restraining you. The 4th hit you in the neck. This resulted in bleeding and a blood clot, which travelled to your brain and has caused some damage. It has also resulted in physical problems. It means you now use a wheelchair, and you have real problems with your communication, often using a whiteboard to help you communicate. It is entirely due to your deliberate and voluntary actions that you have those injuries. But I have regard to the impact of imprisonment on you in the light of the totality of your injuries. I am satisfied that adequate treatment can be provided in custody. Even so, I recognise that custody is likely to be more difficult, both because of your injuries and because of your autism. That is a significant factor to consider when deciding whether to impose a whole life order. Impact on your family. I have read the statement of your mother, and extracts of it were read by Mr. Khan. I recognise the impact that your sentence will have on your family, but that is not a significant mitigating factor. The aggravating factors, in my judgment, outweigh the mitigating factors. The aggravating effect of your use of a gun and the planning and premeditation outweigh the mitigating effects of your personal mitigation, including the impact of custody. There is therefore no justification to depart from the starting point of a whole life order. That is what Parliament has decided should normally apply as a starting point to the murder of a police officer in the execution of their duty. The seriousness of the offence means that a minimum term order is not justified. A whole life order must be imposed. Louis de Zoysa, I sentence you to imprisonment for life. I impose a whole life order. That means you will remain in custody for the rest of your life. You may now be taken from the dock.